Hi, we're continuing in this video to look at the contents of the affidavit that was filed by Prime Minister Andrew Holness in the court in support of his application to the court. He's applying for leave to apply for judicial review of decisions and actions taken by the Integrity Commission in relation to the investigation report into his statutory declarations. I'm Dionne Jackson Miller. Thank you so much for being here. Let's get started. So we're now at page 13 of page 37 of the Prime Minister's affidavit. He's starting now to speak about the companies that are associated with him. And he's speaking now about the way in which the Director of Investigations treated the company known as Imperium, which is wholly owned by him. The director looked at his assets and Imperium's assets together. So let's pick up. The Prime Minister spoke of this as an error, and he says it's important to understand how the error arose in terms of the conflation of assets. In 2020, he said after public concerns were raised that he was a shareholder and director of ADMAT Incorporated, an international business company incorporated in St. Lucia, he made the decision to wind up ADMAT and replace it with a company incorporated in Jamaica. He says accordingly, ADMAT's assets were transferred to the company called Imperium. The process of transferring assets from ADMAT and from him personally to Imperium was completed in 2021. He says for the avoidance of doubt, this transfer of assets related to existing assets that were owned either by him personally or by ADMAT, and that those assets had been previously reported in his statutory declarations for the prior years that were certified by the Integrity Commission. He said his residence is owned by Imperium. He says as public concerns were raised that he had his assets in a tax-favorable jurisdiction, he became concerned about their views from a transparency perspective. Because of that, he formed Imperium and he brought the asset, the house, into the jurisdiction from ADMAT, which was in St. Lucia. He says in relation to that, he incorrectly attributed the value of the house as shareholder investment for the 12-month period ending the 31st of December 2021. However, he says he was advised by his lawyers that it's not correct, as it made it appear that it was quote-unquote new money when it was not. On the 31st of August 2023, he attended a meeting at the office of the Prime Minister with the Director of Investigation and his team, including Stephanie Fiddler-Blake, a forensic accountant, and two other officers of the Integrity Commission who appeared to be responsible for the secure recording of the proceedings. He was accompanied by his lawyers. It was already understood and agreed that he would not answer any questions at that meeting, as the questions would have been put in writing. The meeting was to formally start the investigation. His lawyer also raised the issue of the incorrect completion of the form and whether there was scope for correcting the form. This was in part because the areas for concern for the investigation substantially related to juristic persons. He's talking here about the companies. Remember, registered companies in law are legal persons. They have what is called legal personalities. The Director of Investigation also stated that there were some transactions to the value of over $1 billion, and they were trying to account for approximately $350 million. Mr. Holness says he and his attorneys expressed spontaneous shock at this, as they had attended the meeting to deal with 2021, and there was no such figure on the 2021 declaration or financial statements. After this expression of shock, the Director of Investigation and or Mrs. Fiddler-Blake clarified that this was not for 2021, but based on bank statements for 2021 up to June 2023. Mr. Holness says he and his lawyers were relieved. They pointed out that they were not comparing apples with apples, so they should tell them a figure related to 2021. It was agreed that written questions would come later. Based on the representation by his lawyers about the reason for the sum of $350 million and how it was arrived at by reference to an incorrect period, he said he expected this would have been corrected when the additional questions came. But he said when they came, they still contained questions about a period beyond 2021. The Director of Investigation responded to his concerns. His response confirmed the area of concern, as stated above, being dealings with the companies Imperium, Positive Media, Estate Bridge. The director agreed that the companies are juristic persons and therefore separate from Mr. Holness. Notwithstanding, the director said there are concerns around the purpose for which the companies were established and their use. In relation to the procedural matters, he said he had provided particulars of the assets, including the value of the assets that require explanation, with the understanding that more specific questions would be asked during the interview. Mr. Holness says that letter did not address the objection which had been raised regarding subject matter of the investigation or the provision of the disproportionate figure that he was required to explain. So he asked his lawyers to write to the director again. He said, notwithstanding the objections and without prejudice to his rights, the answers to the questions were provided as based on the terms of Section 14.5, that's a section of the Corruption Prevention Act dealing with illicit enrichment. He said based on the terms of the illicit enrichment offense, he was at risk of committing an offense if he did not respond at all, even though he understood from the objections made on his behalf, that's by his lawyers, that the threshold for conducting an illicit enrichment investigation hadn't been met. He said, nevertheless, at all times while answering, he maintained his objections, and he indicated that the answers were being provided without prejudice to his rights to challenge the said procedure. But in light of delay in the certification of his statutory declarations, the public interests in having the process completed, his sensitive position as Prime Minister, he thought it would be in the best interest for the answers to be provided so the process could be resolved as soon as possible. He said in instances where the questions were outside of the scope, meaning beyond the 2021 period, and he limited his response to the 2021 period. 25th of October 2023, his lawyers got another letter with additional questions for clarification. He said along with his lawyers, he reviewed the additional questions. He noticed that the period had been expanded to 2022 and 2023. He said this was of particular concern as at that time the statutory declaration for 2023 wasn't due. So his lawyers responded and objected again. The Director of Investigation confirmed receipt of the responses and said that his inquiry into allegations of illicit enrichment couldn't be limited to a particular year. His lawyers wrote back. We're now at the 3rd of January 2024, saying the investigation was out of scope, alleging confirmation bias and complaining about delay. He said his lawyers told him confirmation bias means that the Integrity Commission had arrived at a conclusion without evidence and then were looking for facts to prove that conclusion. His lawyers were also concerned about the delay in dealing with the matter. So on the 2nd of February 2024, there was a meeting. At that meeting, the Director of Investigation explained the cause of the delay as being related to requests they had made of third parties, other people or entities, as well as their failure, Mr. Holness and his lawyers' failure to respond to questions related to 2022 and 2023. These were questions that Mr. Holness's lawyers said were outside the scope of the referral. They're saying the referral had been made in relation to Mr. Holness's 2021 declaration. So they're saying you shouldn't now be asking him questions about any other years. He says no, he's advised that the outcome of the investigation does not have to be charges. It can also be recommendations. And his lawyers also pointed out that based on the nature of the quote-unquote supposed investigation as being one for illicit enrichment, it can't be based on a date after the allegation was made. They also said the 2022 declaration hadn't been referred for investigation, but they said the question should be put in writing so they would decide whether to respond or not. So, in a letter on the 8th of February 2024, the Director of Investigation made his formal request and also tried to explain why the investigation was going so slowly. His lawyers answered, saying the agreement to provide the information was based on the director's indication that the investigation would also cover the 2022 statutory declaration. He said they advised the director that they were not aware that the 2022 declaration had been referred, and if that was the intention, it should have been stated given what the Corruption Prevention Act says. Mr. Holness says, in light of his lawyer's concern that the investigation had now moved to the 2022 declaration, even though that had not been referred, he asked them to ask for information from the Director of Information and Complaints if he had started to look at the 2022 declaration. That director said he had not started to look at the 2022 declaration because he was awaiting the outcome of the investigation into the 2021 declaration. In the meantime, the Director of Investigation was saying he was not limited to the 2021 period, that he wanted the responses on the 2022 declaration. He asked for answers to additional questions and said he couldn't say why the statutory declaration hadn't been certified because that was not within his remit. Mr. Holness and his lawyers on the 18th of March 2024 requested an extension of time to respond and also reiterated their objection to the fact that the investigation was now including 2022 and 2023. The director sent further questions requesting for the first time income and expenditure statement for the period ending 2021 as well as 2022 and information concerning the NFE bond issue properties owned by Estate Bridge. Mr. Holness says there was some delay in responding to that request for various reasons, including the passage of Hurricane Beryl. He said at that point, the Director of Investigation, as he understood it, was at the end or in the process of closing out the investigation. He said his lawyers tell him that the request for the income and expenditure statement at that stage of the investigation was irregular, unfair, and unreasonable, especially since they had consistently objected to the substance of the investigation. And they said it had not been established that Mr. Holness owned assets disproportionate to his income that would require him to provide an explanation under the Corruption Prevention Act. He said accordingly, his lawyers enclosed a response to some of the questions. And they also said that those responses were subject to his objections. And the objections had to do with the fact that the 2022 declaration had not been examined by the Director of Information and Complaints, and that it was improper and not in keeping with the Integrity Commission Act for the Director of Investigation then to be examining the 2022 declaration. They also objected to what they said was lack of due process and procedural impropriety. They said the due process principles hadn't been observed, including non-compliance with legal requirements, procedural safeguards, and constitutional guarantees. They objected to delay. They said the investigation was not conducted promptly, and because of that, Mr. Holness had suffered injustice and ignominy. Also, that he was being investigated without regard for conditions precedent to Section 14.5 of the Corruption Prevention Act on the pain of prosecution. They're saying he was being investigated for something for which the conditions had not been met for the investigation to begin. And he said he would not provide an income and expenditure statement because it was not required. He said it became clear that the Director of Information and Complaints had abdicated his independence, fairness, and duty to examine the declarations for 2022 and 2023 to the Director of Investigation. Similarly, he said the Director of Investigation was unmindful of the objections to his abuse of authority and breach of statutory duty. The Director of Information and Complaints on the 12th of February 2024 was asked if he had examined the 2022 declaration. He said he hadn't done so. He was waiting on the outcome of the 2021 investigation. Mr. Holness says this was almost 1 year after the declaration was properly filed as required by law. He said that prejudiced his interest and threatened to cause further prejudice, as by this time the public was questioning the delay, fueled in part by political party partisanship. He said the delay in examining his 2021, 2022, and 2023 declarations created a cloud over him that's personal to him and that affects his interest significantly. He said given the detailed nature of his objections, he expected he would get a response or a hearing would have been convened. He says instead, the report was sent to the Director of Corruption Prosecution. The only matters that had been referred to the Director of Corruption Prosecution on the 19th of July 2024 were in relation to the 4 accounts that had been left off his statutory declaration and in relation to the offence of making a false declaration. He says he now sees from the reports and letters submitted to Parliament that the report dated 30th of August 2024 was submitted to the Director of Corruption Prosecution on the 19th of July 2024. Among other things, he said it fortified his belief that the report was complete as of the 24th of June 2024 and at best by the 19th of July 2024, as it is his understanding from the Integrity Commission Act that the Director of Corruption Prosecutions gets the file for consideration once a completed report has been submitted to the Integrity Commission with a recommendation of anything that is to be referred to her. He says, in addition, the only matters submitted were done by the Director of Investigation, not by the Integrity Commission. In addition, the Director of Corruption Prosecution reported she didn't find a basis for prosecution in relation to those 4 bank accounts. He said it then came to his attention in the public domain that the Integrity Commission had submitted its report and the report of the Director of Corruption Prosecution to Parliament for tabling. He said he was appalled when he read the report in light of the objections that had been made on his behalf. He said he's been informed by his lawyers and believes that there was no finding of reasonable suspicion of corruption or an offence under the Integrity Commission Act in respect of any matter outside of the 4 accounts. He said it was a fishing expedition into the business or affairs of him and the companies. He said in relation to the 2021 declaration, the second respondent, that's the Director of Investigation, in his report stated at least 3 times there was no unexplained growth in his net worth. There's a negative net worth of over $10 million. He said for 2022, which is still awaiting examination by the Director of Information and Complaints, there are no statements of the value by which his assets are disproportionate to his lawful income. The report states a negative net worth of over $5 million. There is a statement that the sum of $1.9 million was found, which he is required to explain. He says there are 3 reasons this is unreasonable or irrational. 1, the sum was arrived at, he says, by unlawfully combining the resources of him as well as Imperium. He said 2, the sum was never put to him for explanation. The first time he saw it was in the report. 3, he says the sum of $1.9 million cannot properly be regarded as disproportionate so as to trigger the requirement for him to explain it. He says it's therefore a breach of duty or abuse of power and or discretion when the Director of Investigation stated that he was unable to come to a conclusion or complete the report because Mr. Holness refused to supply information to allow him to assess the sum of the $1.9 million. He said the figure of $1.9 million was never provided to him for explanation as is required by an investigation for illicit enrichment. It's a figure arrived at, Mr. Holness says, only because the Director acted in excess of his authority and unlawfully when he pierced the corporate veil of the second applicant. That's Imperium, piercing the corporate veil, meaning looking behind the fact that the company, as a registered company, has legal personality in its own right, and instead the Director looked at the assets of Imperium and combined them with those of Mr. Holness. Mr. Holness is saying the director acted unlawfully in doing so. He goes on to say the finding and conclusion and decision that the 1.9 million is disproportionate to the combined incomes of him, Mr. Holness, and Imperium is unreasonable and irrational. He says disproportionate doesn't mean more than, it means too large or significant. He says this is less than 10% of his lawful earnings from all sources. Notwithstanding that the Director of Investigation's finding that the offence of illicit enrichment wasn't made out against him in relation to the 2021 declaration, he says the Integrity Commission continues to fail to certify the 2021 declaration. He said notwithstanding the Director of Investigation's failure to find that the offence of illicit enrichment was made out in relation to him in relation to his 2022 declaration, the Director of Information and Complaints and the Integrity Commission have failed to certify that 2022 declaration. He says the Integrity Commission has also tried to refer the 2022 statutory declaration to the Financial Investigation Division and or to delay the certification of the 2022 declaration pending investigation by the Financial Investigation Division, and Mr. Holness says that is improper in all the circumstances. He says they knew the request for income and expenditure was a ploy to continue the illegal and unfair investigation and knew if they communicated to the public that Mr. Holness had refused to submit information, the public sentiment would be stirred up against him. He says the investigation was procedurally unfair and pursued for an improper purpose from the outset, as the respondents, that's the directors and the commission, failed to provide him with the sum or the wealth that was disproportionate to his lawful earnings and reserved to themselves the right to ask any question and questions that were not relevant to the required explanation. He said it's now clear from the report that they withheld information from him as they knew the sum they were concerned about was 4.4 million. He says they knew that this sum was no longer a concern for 2021 as it's disclosed in the report that he landed at a negative net worth. He said procedural fairness required that the Director of Investigation and the Commission provide him with adequate notice of their proposed decisions at every step of the investigation, or at best before making recommendations adverse to his interests, and to give him a chance to respond. He said they made adverse findings against him without giving him an opportunity to respond based on statements from undisclosed witnesses whose statements were not put to him in the making of those adverse findings, conclusions, and recommendations. He says the three companies were treated in the same way, as they weren't given fairness or hearings on their behalf. He said the findings of fact and conclusions about the bond are also unfair. He says he responded to all questions, he explained the error, no further questions were asked of him, and he's concerned that the adverse findings were made and he wasn't given an opportunity to respond. He said the investigation was procedurally unfair because the commission represented that they were proceeding under Section 14.5, that's the illicit enrichment section of the Corruption Prevention Act, but instead they went on to ask about the business and affairs of him and the companies without reference to the procedure for investigating illicit enrichment or telling him exactly what he was required to explain or the new matter that was discovered. He said the Director of Investigation proceeded unfairly by broadening the scope of the investigation, resulting in a moving target such that he demanded to investigate 2022 and 2023 declarations, such that the investigation turned out to be no more than a fishing expedition, and in respect of which he made findings and decisions adverse to his interest. And he also refers to the director's terms of reference in the report. He says the decision, findings, and conclusions relating to the combined net worth of 1.9 million is unreasonable and irrational because the Director of Investigation and the Commission failed to have regard to the finding in the report that Mr. Holness's net worth for 2021 and 2022 was negative and there was no unexplained growth in net worth. He says they acted ultra vires, the Integrity Commission Act, meaning outside the legal scope. They acted illegally, he says, or in a procedurally unfair manner in lifting the corporate veil, having not found fraud or reasonable suspicion of corruption or an offense under the Integrity Commission Act in relation to any matter outside of the 4 accounts. He said it was also unfair in circumstances where the finding in the report was that there was no unexplained growth in his assets. He says they acted in bad faith and unfairly in recommending in the report to the Integrity Commission and the Integrity Commission submitting it for tabling in Parliament. He said that's because at the time when the finding was made, he had not provided the income and expenditure statement. He said at no time was a forensic report put to him for comment given the seriousness of the matter and given that findings of fact and conclusions were arrived at in relation to it. He says he was entitled to know if there was any exculpatory evidence in it, especially because the 30th of August 2024 report was completed and submitted to Parliament and there was heavy reliance on it. Exculpatory evidence meaning was there evidence that suggested that Mr. Holness had done nothing wrong. He says the referrals to the Financial Investigation Division and Income Tax Department are improper, and there is no bar to the certification of his declarations. He says the Director of Investigation acted ultra vires, the Integrity Commission Act, and or illegally having completed his report, having not made any statement of reasonable suspicion of corruption or an offense under the Integrity Commission Act in respect of any matter outside of the 4 accounts. He says referring the report and findings to the Financial Investigation Division and Tax Admin represents an unlawful delegation and or abdication of their statutory responsibility. He said it was also straying into areas that were not referred and not the subject of the Integrity Commission Act for report to Parliament. He says the tabling of the report was intended to embarrass and harm him, and as such was made for an improper purpose and in bad faith to prejudice and harm him, given that the entire scheme of the Integrity Commission Act is to ensure confidentiality and secure fairness to those who are being legitimately investigated. He also references a special report dated the 5th of September 2024. He quotes the Integrity Commission saying there can be no finality in the matter until the Financial Investigation Commission has completed its work, and says there can be no certification of a statutory declaration until the Director of Information and Complaints is satisfied that the statutory declaration has been duly completed. He said the statement is contrary to what the law says, as a responsibility to complete any work under the Integrity Commission Act is placed on the Director of Investigation and the Integrity Commission and no other entity. He said the Integrity Commission statement that there can be no certification of a declaration until the Director of Information and Complaints is satisfied that the statutory declaration has been duly completed is made based on an unlawful foundation in that it presumes that the Director of Information and Complaints satisfaction is to be generated by the work of others, in this case the Financial Investigation Division, and he says there's no lawful statutory basis for this position. He says in any event this shows that the Integrity Commission has encroached on the proper performance of the duties imposed on the Director of Information and Complaints, and it also shows, he says, that the Director of Information and Complaints has abdicated his duties to the Integrity Commission. He said by their actions the Director of Investigation and the Integrity Commission have usurped or encroached on the statutory role of the Director of Information and Complaints. Okay, I am just going to skip a lot of this because this is now just a whole heap of repetition, all right? So I'm scrolling down. You're not missing anything because all of this has been said. I've probably repeated it 10 times. All right, so he then says he has a legitimate or reasonable expectation that the Director of Investigation and Integrity Commission would have observed the principles of natural justice, procedural fairness, complied with the Integrity Commission Act and any other relevant legislation, and considered relevant considerations in conducting its investigation, which led to its findings, conclusions, and/or recommendations. He said they have failed to observe the principles of natural justice and procedural fairness in dealing with his declarations. He said that conduct has breached the principles of legitimate expectation, which requires them to act impartially, fairly, and independently. He says he believes the entire report is impeachable on the basis that's set out in the notice of application for court orders. And in my next video, I'll go through those plenty court orders. And he says his constitutional rights have been breached. He's also saying there's no other form of redress that's available. In any event, judicial review is more convenient, suitable, effective, efficient, and expedient. Okay, so that's the end of the Prime Minister's affidavit. So this is the Prime Minister giving sworn evidence saying this is what happens, and this is supporting his application for leave to apply for judicial review. Again, remember, judicial review is a two-stage process. So you first have to apply for leave permission to apply for judicial review, and this is done to weed out frivolous claims. If the court gives you leave, gives you permission, then you then go on to apply for judicial review, and that's where you have the meat of the matter, the substantive hearing. All right, I'm going to leave it there for today. Watch out for my next video now, which looks at the whole heap of court orders that the Prime Minister is asking for. Thank you so much for being here. I'm Dionne. I'll see you next time.